And then I did say that we're not going to have testimony today. Is that correct?
We would.
Oh, we would. Okay, in the afternoon. Okay. Otherwise, we'll still try. Does anybody want a warning if they're warning or nobody needs that?
I do one. Same thing.
Oh, States, you want to move your box?
So.
Right into books. I know sometimes people don't want to sit at the table, which it would be so much better if people sit at the table, but I know people like to walk around. So when you're walking around, make sure that you don't block Brenna's view when you're talking to people, because it makes it a little bit harder for her. And we all wear glasses, and I know Robert, you wear glasses, other people don't. So you can't see.
Oh, I see great. It's the little dots up front.
Okay.
I see everything beautifully.
Well, he don't understand it. He wears glasses, and we can't see you who you hear. Why that is, I don't know.
I'm just saying, Brandon, you tell me, slow down and speak up. Wait a second. It's hard to walk around here.
Yeah. Probably, as you know, I don't walk around.
Yeah, I know, and I hate that.
But the fact that they don't walk around.
Yeah.
It works fine for me.
It worked great.
You know, I would start, honestly, it became a necessity to fight cases by yourself. And, you know, Judge,
Yeah.
she would make these rights and wrong.
Hmm.
So you'd be walking around, and you
Those
have
are-
to turn around and they strike.
Yeah.
Calls, like granted,
So Harold did it too.
I always wondered, did you know that?
I don't think they care.
Yeah. And then I always think that, you know,
They're listening to what they're saying. Hey, my same thing.
Our last trial, Robert and I had a guy that just got up and left for 15 minutes, no more there.
You knew it was gonna be bad. We're not.
Yeah, one in charge. See,
The judge.
I have
said,
those in
okay,
charge.
I feel we have sure nobody's around to go.
State has the right to a jury trial.
More? Aren't we just
I have
about
one
done
in
here?
charge.
Right.
Before I
State
even
has
start.
the right to a
oh, yeah,
you know, we're not like- we're not agreeing to that trial. They would figure it out. Folks, I have to agree with them. They're not agreeing to it.
Well, I don't.
Judge, we're missing 2, 10, and 15.
Only have a jury trial, that's supposed to have a position.
All right, we all want to proceed without 10 and 15, before we can get 10 and 15 show up. I would provide extra time for your, it's
I need the family to stay right behind there. Are green chairs?
section from doing that, say,
Judge, I got checking to see who they are. It was 2, 10, and 15.
no, 10 and 15.
It's 10 and 15. There's the green chair. Yes, there's. And we need all of these.
If you all have phones, make sure they are turned off. And don't put them on vibrate, make sure your phone is turned off. Nope.
I don't want to.
No objection.
All right, for adjourned.
Number one, this way now. First row, way at the end, and there's a number on the chair. And just sit on your number. Number 8. The second row, way at the end. On top. Fifteen. You're in the section. You're 9. 15. Juanita Garza. Dalia, you're 18, Dalia. Yes, ma'am. We're here. Yes. 21. 22. Let's go. I present. You're 23. 24. 25. 27. Diana Guerrero. 28. John Smith. 29. Mark Orleans. 30. Daniel Vincent. 26. 31, 32. 34. Jacqueline Estrella. 35.
Oh, no, please.
36.
You see that? We're standing for you all.
Oh, okay. 39 Stephen. As a like Mary. 42. 43. 44. Linda. 45 and then 46. 47. 47 Julie. 48 Carl. 49 Martha. There's no 50 years old. You're 51, 52 Robert. Lorenzo, 53. Linda, 54. Michael, 55. Renal, 56. Sandra, 57. Philip, 58. Paul, 59. Albert, 60. 61. 62. 63. Olaya, 64. 65. 66. Brian, 70. 8. Diana. 69. Nathan, 70. Melissa. 70. Yes, there's no 70. There's no 71. Okay, we're gonna fix that. So we 72 with Candy. 73. Michelle. Janet Summer Willie. Summer Rose.
And there's someone we got so weird.
All right, good morning, everyone. Okay, that's a little bit weak. I mean, it's the beginning of the day. It can't be that bad because it's the beginning of the day and great things can always still happen. Good morning, everyone. Good morning. That is so awesome. All right, I want to welcome you all to the 187th District Court. I'm Judge Stephanie Boyd. You're on the 4th floor and you're in the 187 District Court. So what's our court number? 187. What floor? Okay, then that went off a little bit. All right, so what's the court number? 187. What floor? Who's the judge? Somebody said.
Regional.
Yeah. All right, let me just tell you the reason why I do that is because whenever you all are brought in as a group and the state and the defense and myself start questioning you as a group, you must stay as a group. And we've had trials in here before where we're waiting for a juror and we're wondering, where is that juror? And one time we found out that the juror was down the hallway entering into another trial. And we're like, you're supposed to be here, not on that trial. And then one juror we were waiting for, and they found us because I do that every time I have jurors come in and they're like, I looked up and everybody was gone. Because sometimes I give you breaks. So you'll be able, if you're able to tell them I'm in the 187 District Court and you get lost, somebody will be able to direct you here. Or if you just remember my last name, Boyd, I'm the only Boyd who's a judge in the courthouse. So they'll be able to point you where we are. Does everyone understand?
Yes.
All right. So to my right, I have someone who is very important. That's Brenna DeMoss. She's our court reporter. So she takes down everything that everyone is saying. So I'm going to give you guys instructions that I give to every jury panel that we have up here. And so far, only one jury panel has gotten it right. And so I have faith that you all are going to get it right. So we're going to make Brenna's job easy today. So what that means is only one person talks at a time. And if you're in the jury box, so there are 2 rows, you don't have to stand up when you speak because Brenna will be able to hear you. If you're on this first row here, you don't have to stand up to speak because Brenna will be able to hear you. Everybody else, when you speak, if you can, please stand up because that will make it easier for her to hear you, okay? Everybody understand?
Yes.
Are we going to be the second panel to do that correctly?
Yes.
All right. The other thing, I've already told attorneys for the state and attorneys for the defense, do not stand in front of you as far as blocking Brenna's view, because the people who wear eyeglasses understand, and Brenna has her contacts in today, but people who wear eyeglasses understand that even though we have exceptional hearing, if we can't see your face, for some reason, we can't hear. So they're not going to block the view for you. All right, I've introduced myself. I want to let you know that today we have people who are sitting over to my left. The courtroom is open to the public, so anyone who wants to come in can come in and view voir dire. But the persons to my left are here in support of the defendant, in this case, Mr. Curry. But I'm going to have attorneys for the state introduce themselves. Attorneys.
Morning, my name is Marcus Sanders.
Morning, my name is Daniel Escobar.
All right, defense.
Good morning, ladies and gentlemen. My name is Robert Porter.
Good morning, I'm Kelly Piddle.
All right, and if you could have your client introduce himself.
Lamont Curry.
All right, does anyone know or recognize any of those parties? Okay, all right. And other than you all meeting for the first time downstairs or in the hallway today or yesterday, do you know anyone on the panel other than just meeting outside in the hallway? Okay, that's very strange because usually we have a teacher, their student is on there, or coworkers. Sometimes we've had people raise their card and nobody else recognized them. And I'm like, oh, that's sad. And then one time we had a wife and ex-wife on the panel together, but they were friends, so it went well. All right. So in your hand, you have something that is very expensive. It can be used as a fan, which I see some people are using it. I am sorry for the temperature in the courtroom. We do have a thermostat back here, but it doesn't control anything. And I've complained about the AC, but to no avail. I've been complaining about it since 2019. So I apologize for that. But you have those cards that are extremely expensive. Could everyone raise their cards for me? All right. Awesome. And I see number 9 has their, I always see how we're going to go by the numbers being turned right. So 9 and 6 are turned right. So it's going to be great. So anytime you have something you would like to say, or maybe the attorneys ask you something, or I ask you something that applies to you, please raise your card and they will call on you. All right. So first off, the charge in this case is robbery. I just want you to think about that for a second. And then both parties will have a chance to speak to you. I want everyone to know that when I speak to you, when attorneys for the state or the defense speak to you, they are not talking about this specific case. They're talking about hypotheticals. So none of what they say is about the facts in this case. The only way you will hear the facts in this case is if you end up on the jury. Does everyone understand?
Yes.
Now, how do people come to court? How many people have ever had a traffic ticket before? Don't be shy. Practice raising your cards. Say, I ask these questions so you can practice raising your card. All right. There are some people who never had a traffic ticket before. Well, we say, bless you. And hopefully that streak continues. So I've had a traffic ticket before. I've had one. And when I got a traffic ticket, that was back in the day where they used the paper and they give you the paper, right? Well, now I think they do it digitally. And so when you get a ticket, let's say it's for running a stop sign, or in San Antonio, because people don't know what the yield sign means. Let's say it has to do with the yield sign. And the officer pulls you over and they give you a ticket, you accept the ticket. All right, when you accept that ticket, you're not saying, yes, I did run the stop sign, or yes, I didn't follow the laws as it relates to yield signs. That officer is giving you a ticket to let you know, I'm saying that you didn't follow the proper yield, you didn't yield at the yield sign, or you ran a stop sign. This is where you need to appear in order to address this issue. This is the date and time. So then when you go to take care of that traffic ticket and you want a jury trial, that traffic ticket is not an evidence of your guilt. It's just to give you information so you'll know what you're going for. I don't think anyone here would like to think I'm showing up for running a stop sign, and then you get to court, they're like, oh no, we're talking about you running a red light. So an indictment is the same thing. In felony courts, an indictment is to let the defendant know, or a person who's accused know, what they're charged with, where they need to appear. Does everyone understand?
Yes.
So an indictment is not an evidence of guilt. It cannot be taken by anyone here to mean anything. It's just a process by where a person is brought to court and given information on what they're charged with and where they need to appear. Does everyone understand?
Yes.
Is there anyone here who cannot follow that? All right. So everyone understands an indictment is no evidence at all, and it cannot be taken as such. Does everyone understand?
Yes.
Is there anyone who has a problem with that rule? Okay. Now, how many people here, and I'm going to age myself, how many people here are seeing Perry Mason, Matlock, Mannix, Barnaby Jones? Thank you. See, I'm going through the list. Paper Chase, The Practice, Injustice for All. I can continue. Thank you, number 14. You're with me. All right. So then how many of you have heard the term right to remain silent? Is there anyone who hasn't had that term? If you have not, I'm a professor, but I'm going to blame the teacher. If you have not had that term, I'm going to blame the civics teacher, although I don't think they have civics classes anymore. Well, everyone who's accused of an offense does not have to give testimony in their case. They can remain silent, and you are not to consider that in any way. Now, some people are maybe like Miss Kravitz from Bewitched. You want to know what's going on in the neighbors and you want to say, I wonder what they would say. I wonder what they would do. Well, here's the thing with the right to remain silent. You cannot consider that whatsoever in determining whether someone's guilty or not guilty. Does everyone understand?
Yes.
Is there anyone here who would hold it against someone if they decided not to testify? They decided to remain silent. Anyone?
Oh,
Now, everyone is presumed to be innocent. So just because someone is brought in for a jury trial doesn't mean that they're guilty. They are presumed to be innocent unless and until the state proves their case beyond a reasonable doubt. So right now, if you're here for jury selection, you haven't heard any evidence, and the presumption of innocence alone is enough to acquit or find someone not guilty. Does everyone understand?
yes.
So the burden rests with the state, and that burden is proof beyond a reasonable doubt. When I graduated from law school, you had to know the definition of proof beyond a reasonable doubt. When I tried my first jury trial in 1997, of course, my mom was excited. She wanted to know what happened and how did you do? And I'm like, I memorized the definition. And I tried that first case. And then guess what? Second case, there is no longer a definition for proof beyond a reasonable doubt. So what I would always tell jurors when I was a prosecutor and defense attorney, I would always tell them what proof beyond a reasonable doubt is not. So you're on the criminal side of the courthouse. The red brick with the green rooftop is where they try civil cases. And their burden of proof over there is preponderance of the evidence, more likely than not that someone did something. The highest burden on the civil side is a burden called clear and convincing evidence. That's the burden that people use in order to terminate someone's parental rights. So that's the burden that's used to say, we can't trust you with your child, so you will no longer legally be this child's parent. Does everyone understand?
Yes.
The burden of proof beyond reasonable doubt is a higher burden than that burden. That's the highest burden we have. Does everyone understand?
Yes.
Now, the state must prove each and every element of any offense that they're trying beyond a reasonable doubt, proof beyond a reasonable doubt. Now, there are two phases to a jury trial in Texas. The first phase, people call it guilt innocence, but really the first phase is really whether you're deciding whether somebody's guilty or not guilty. You're not really deciding if someone is innocent. Does everyone understand?
Yes.
All right. And the second phase is called the punishment phase. Before anyone goes to trial, they have to make a decision or an election on if they were to be found guilty, who would give punishment? Would it be the jury or the court? The law requires that someone makes that election. The fact that someone is making that election doesn't mean that they're saying they're guilty, and you are not allowed to take that as an evidence of guilt. Does everyone understand?
Yes.
So in this case, Mr. Curry has decided if he were to be found guilty, he would come to the court for punishment. Is there anyone who's going to hold that against him?
No.
All right. Now, I want to talk to you about the one witness rule. I'm going to give you a hypothetical. Do not add anything to the hypothetical. Don't ask yourself, well, I wonder if it was dark out. I wonder if there are other witnesses. This is the hypothetical. A witness comes to testify at trial. Only one witness testifies. That witness proves each element of the case that the state has to prove beyond a reasonable doubt. Is everyone with me on the hypothetical? Let's say the witness is Mother Teresa, or it can be the Pope, or whoever you think is a credible witness. This is this hypothetical witness. They're credible. You believe them. You have no doubt whatsoever in your mind that they are not telling the truth. they're telling the truth, they're credible, and they prove the state's case, every single element. Is there anyone here who will still say, yeah, they prove the state's case, but I want more? All right, that is 12, 13, 41, 43, 1, 62, 66, 26, and 36. All right. And for those jurors who raise their cards, when you say you want more, I want to make sure that you understand the hypothetical. The hypothetical is you believe that witness. So for example, usually the one witness rule, to explain it to people, this is what some attorneys will say. They will say, you're in an alley and you're by yourself. All right. It's dark. And let's say someone shoots you. And it's just you. You're the only witness. And you are the person that the state is calling to testify. Is that enough? And you're a credible witness. And everything you say is believable, it's credible. So I want to make sure that the jurors understand the one witness rule. So of those who raise your hand, does that change your opinion? If it does, raise your card. All right, 12, 13, 36, 26. All right, so that leaves jurors 1, 41, 43, 62, and 66. Is that correct? All right. Now, this question, I always wonder how to ask it, because if nobody's understood what I'm saying because English is not their first language, then they're not going to understand this question either. But this is the way I've decided to start asking it. Is there anyone here whose English is not your first language? All right, 14, 29, 18, 22, 32, 37, 38, 45, 49, 61, and 63. All right, juror number 14. What is your first language?
I was born in Puerto Rico. We spoke Spanish.
Okay, awesome. I have friends who live in Puerto Rico. It's beautiful. I haven't had a chance to visit yet, though. So have you been able to understand everything that I've been saying? Okay. Juror number 18. What is your first language?
Spanish.
All right. Have you been able to understand everything that I've been saying?
Rocky.
Rocky. Okay. Juror number 22.
Yes.
All right. What's your first language?
Spanish.
And you've been able to understand everything that I've been saying?
Yes.
All right. Thank you. And thank you for standing. We're off to a good start. Juror number 29. Don't disappoint me.
My first language is German.
Oh, wow. I'm planning on going to Germany at one point. What part should I visit?
Munich.
All right, I'm going to go there. I'm going to mention your name.
Marlies Sanders.
Okay, I'm going to mention it. Thank you. Have you been able to understand everything?
Yes, ma'am.
All right, thank you. Juror number 32. What?
Spanish.
All right, have you been able to understand?
Yes.
All right, thank you. 37. Yes. First language? All right, have you been able to understand? All right, juror number 38.
Yes, ma'am, Spanish, but I understand everything.
All right, thank you. 40. Oh, see how he's on top of it. He knows the question that's coming. Number 45.
The Philippines, Filipino, Tagalog. And
Oh.
yes, I do understand.
All right, I've never been to the Philippines. What part should I visit?
Manila.
All right, I'm going to go there and mention your name. All right. Number 49.
Spanish.
All right, and have you been able to understand? All right, thank you. 61.
Spanish?
All right, and have you been able to understand everything? All right, thank you. Number 63.
Spanish and yes.
Okay, thank you so much. It's always nice to hear different languages and find out where everybody is from. All right, the next question I'm going to ask you is about time constraints. Is there anyone here who has tickets to go somewhere and you can't put those tickets in my name? Is there anyone who's here like this? Okay, number 12, 6, 14. Oh, wow, just 1 second. Let me try to put you in order. 12, 13, 14, 6, 23, 43, 46, 55, 58, 60, 68, 67, 73. And you can lower your cards once I call your number. All right, juror number 6, what's your time constraint?
Saturday next. I have tickets for the 27th.
Where are you going?
Florida.
What are you going to be doing in Florida?
Visit my father.
Does he want to see you? Okay. So that's Saturday next. All right, somebody have to do the calendar on Saturday next. I'm sorry, which date?
27th.
All right. Number 12. Yes, where are you going?
Traveling the 25th to the 30th to California for my grandson's second birthday,
25th through when?
the 30th.
Hey, congratulations. But here's the question. Are you going to go there and will he remember you being at his second birthday?
No, it's me, yes.
All right. Can they Photoshop your photo in or no? So they can, you can say, I was there.
FaceTime him all the time, so.
All right. Number 13, where are you headed?
I don't have tickets per se, but I have a child under 12 to pick up after school. Today he'll be walking home for the first time by himself. They
Oh.
wouldn't excuse me because he's my grandson who's been living with me for 5 years. But because I don't have legal custody, they wouldn't excuse me. But
Okay.
I'm hoping this ends before.
Oh, so under 12, he's in elementary?
Yes.
Well, I hope he's going to have well, I know he's going to have a great year. I'm not going to say hope. He's going to have a great year. All right, number 14.
Good morning, Your Honor. From the September 7th to the 13th, my spouse and I we had plans to, or tickets bought to go to New York City for our only grandson's birthday.
Oh, how old is he?
I mean, he's gonna be 2,
Okay.
but this is the first birthday for us being with him.
All right. Well, I don't anticipate us being here September 7th, but enjoy, make sure you're in all the photos. I guess they don't do photos now, but I still do. All right. Juror number 23.
Me and my daughter went to the Dominican Republic, September 15th to 22nd.
Oh, what are you guys going to be doing there?
I went to an all-inclusive resort.
Ah, so you're going there to have fun.
Of course.
Okay. All right. Well, enjoy. And you can't give me that ticket. You can't give me that ticket. Okay. You didn't even think about it. You could have thought about it. All right. Number 43.
Hi, that answered my question, because you said you don't anticipate to be here past September 7th. Mine would be in October, but I thought I'd just pick up.
Oh, where are you going in October?
The last three.
Oh,
Like Seattle, from Port Seattle to Seattle. And I'm gonna go to Alaska.
I have never been to Alaska or Canada. Ah, a wedding. Whose wedding anniversary? Okay, awesome.
I think I'm married at 15. No, I'm kidding.
Well, enjoy. Take a lot of photos. I've never been on the Alaskan cruise, but people tell me I should do it. So I'm going to try it. All right, number 46.
Good morning, Your Honor.
Good morning.
I'm a travel nurse. Thursday or Friday in California for either 3 month or 6 month time.
All right, well, thank you so much.
This Thursday?
Pardon?
This Thursday? Yes.
Yes. All right, number 55.
September 3rd through the 12th, will be in Colorado,
And what are you doing in Colorado?
visiting family, my grandfather.
Does he want to see you?
I hope so.
Yeah, okay. All right, be a good grandchild when you go there. All right, number 58.
I have a training class for Friday scheduled. It's been scheduled for a while.
All right, what is the training class about?
It's a tactical medic class.
Tactical medic?
Yeah, I'm a police officer, so
Okay. I was gonna think you were gonna, when you said tactical medic, I was like, maybe you and the nurse are,
it's for first responders for,
okay.
active crime scenes and, active shooter stuff.
All right, thank you. Number 60.
I'll be in Las Vegas from September 21st to the 25th.
What are you doing in Las Vegas?
Bachelor party.
Okay, so you do know it's flooding there.
I do.
All right, are you still going if the casinos and every place is still flooded?
We'll find out.
All right,
Yes, ma'am.
do you guys have like a second option?
Not right now.
All right, you have to have a plan B.
I know.
All right, thank you. All right, thank you. Number 68.
Yes, ma'am. I didn't know how long this process was gonna be, but if it's not gonna be past the 7th of September, then I'm not going anywhere until December. Be safe.
Oh, great. Where are you going in December?
To Dallas for my sister's baby shower.
Oh, tell her we said congratulations.
Yes, ma'am.
When people raise your card, even though it won't have anything to do with this, I always want to know where you're headed. Yes. Number 67.
Yes, ma'am. Sorry. I'm just gonna drive my brother next Wednesday from the surgery when he gets his wisdom teaching rules.
All right. All right, thank you for letting us know. It's always good to have a sibling who's willing to drive. Number 73. Good morning.
I'm a school psychologist with a special needs campus here in the city. And I'm not going anywhere, but I'm supposed to be conducting and participating in some training today and the rest of the next week for our campus staff.
All right, so I'm gonna need you to speak up a little bit because Brenna can't hear. See how I put that on her? Because really, I can't hear.
Basically, I have time constraints in that I am supposed to be participating in and conducting some training for my staff at my school campus. I'm a school psychologist.
Okay,
That's all supposed to be happening like this afternoon, tomorrow, Friday.
all right, thank you for letting us know. All right, so yes, 29.
I have a doctor's appointment on September 6th. I scheduled that 2 months ago. It's radiology, ultrasound, all kinds. It's just the only day I need.
Okay. All right. Well, we'll send prayers out, but I know they're not going to be needed. But I will tell you that I don't expect this trial to go into September 6th. Okay. All right. Thank you. All right. Before I turn it over to the state and the defense, I'm going to tell you all 2 true stories about me. So, I had an uncle. He's since passed. He grew up in a small little town called Grand Cane, Louisiana. Super intelligent. They would always skip him over. And, during that time, they're like, we're going to skip you to the next grade. So the Vietnam War breaks out. And they started drafting a lot of the boys and young men in Grand Cane. So his thing was, I'm not going to wait to be drafted, and I don't want to pick cotton. I'm not going to be a sharecropper. So I want to go into the military. So in order for him to go into the military, my grandmother actually had to sign for him to go to Vietnam. So he didn't wait for the draft. He went. And I tell that story because today, when you think about it, our country really doesn't ask a lot of us. And people love to say the United States is the best country in the world. They have the best criminal system in the world. People love to say that. But the only thing your country really asks of you, and when I said this last time, somebody said taxes. I'm like, yeah, pay taxes. The other thing they ask of you is for you to serve on a jury, because we can't have a jury trial without jurors. They no longer draft unless the legislation changes, you don't even have to go fight in a war unless you decide to volunteer to go fight in a war. So the only thing your country asks of you is come in, spend maybe a couple of weeks or a week serving on a jury panel. Now, the other true story I'm going to tell you is about my friend from law school. You end up making a lot of good friends in law school. And I wouldn't say a lot, maybe 2 or 3, because you feel like you've gone through something. We went through law school together. We studied for the exam together. So she decided she wanted to do civil. Usually on the civil side, and I can say this because I've done both civil and criminal, usually they don't have a lot of jury trials. So we hadn't spoken to each other, but she said she had jury duty. And she said, Stephanie, let's do lunch. I'm like, that'd be great. Let's do lunch. And it was like no time had elapsed. So we are downtown having lunch. And I say, how is jury selection going? And she's like, oh, it's going fantastic. Now, I know you guys are having a fantastic time here in the 187. But when she said that, I'm like, that's very odd that she would say that. And I said, well, why is it going fantastic? And she's like, oh, I'm not getting selected. I'm like, what do you mean you're not getting selected? She said, it's like law school. She's like, I'm in the back. I'm remaining silent, not answering any questions. So I proceed to start laughing hysterically. And she said, see, he knows he's in the back, not saying anything. So I started laughing hysterically. And she's like, what's so funny? I said, well, I guess we'll be having lunch, throughout this week. She's like, why? I said, because you're going to be on that jury trial. She's like, oh, whatever. And so 5:30 rolls around. I'm like, hey, how's it going? She's like, I'm on the jury. Oh, there you go. So with that, I'm going to turn it over to the state. And just remember, if you're not in these 3 rows, please stand when you speak. And attorneys for the state and defense, make sure that you don't block Brenna's view. And everyone, when you need to answer something, just raise your card. All right, state. And if anyone ever needs a break, just let me know. We have the break sign in here, which is, if you just do that, I'll see it. All right, state.
Thanks, sir. Okay, good morning, everyone. Part of the trial is called voir dire or jury selection. It's our chance to speak to you, and for y'all to speak back to us. It's really the only chance that we get to have a conversation with y'all. The whole point of it is to try to find out if we can be fair and unbiased in this particular case. So everything that we ask, everything that we're talking about, we're not going to get into the facts, but we're just trying to find out how you feel about certain subjects to see if you can follow the law and if this particular case is the right one for you, because not every case is right for someone. As why would someone be unable to be fair and impartial? The judge asked us to introduce ourselves because obviously if you know someone, you probably wouldn't be able to be fair and impartial, right? You would have feelings about them, either you like them or you don't like them. And so we need to know that. And also we need to know if you can follow the law in this particular case. One example that I give is when I was a misdemeanor prosecutor, I was working late one day. I got out like 8:39 and I go to my car, it was parked on the street. We have to pay for parking, which is crazy. We have a parking garage, but it's a long wait. And so I was parking on the street, $5 a day. But I go to my car, I had a bad habit of leaving stuff in my car. And so it got broken into. And so back then I was handling misdemeanor cases and I would handle burglary of vehicles cases. And every time one came in, I was like, is this the guy who broke into my car? Based on nothing other than it being a burglary of a vehicle case. And so I knew that if I ever got called for jury duty, I would be thinking that too. I'd be like, could this be the person who broke into my car? And I wouldn't be able to be fair and impartial because that would be in the back of my mind. And so just keep in mind that the questions that we're asking, the things that we're talking about, we're just trying to see if that sort of situation applies to you in this situation. As the judge said, this is a robbery case, but before I talk about robbery, I'm going to talk about possession of marijuana, misdemeanor case. Can anyone tell me who these people are? That guy. That guy. And then those guys. You think me and my friends? Anyone know that last word? Juror number 30. Yeah, Pineapple Express, Seth Rogen, and Franco. What's his first name? James. Yeah. So if they were called for a possession of marijuana case, do y'all think that they would be able to be fair and impartial? Yeah. Do y'all think that's? Say that again? Yeah. So if they were asked to find someone guilty of smoking marijuana, even though they probably do it on the daily, do you think that they would have a hard time doing that? Yeah. So it'd be hard for them to be fair and impartial. If you're chosen on the jury, you're going to be asked to take an oath to render a verdict based on the facts and the law that's presented in the evidence. So let's talk about robbery. Before we can talk about robbery, we have to talk about theft, because the theft is included within a robbery. If you're chosen on the jury, you'll be given the law from the court. I'm going to go over some of the stuff. I'll give you what the code says, and then we'll talk about it, break it down into like plain English. The code says a person who commits an offense of theft if he or she unlawfully appropriates property with intent to deprive the owner of the property. Whenever a word has a legal definition, it'll also be given to you. In this case, appropriate has a legal definition in the code. It means to acquire or otherwise exercise control over property other than real property. So can anyone tell me what appropriate means to them? Juror number 21. Based on that definition. Yeah, anyone? Juror number 14?
Acceptable,
To what?
acceptable.
Acceptable? Close. Anyone else? Juror number 23. Yeah, so basically, take this is Daniel's water bottle. If I take it from him right here, I'm appropriating it. Does that make sense, everyone?
Yeah.
And so appropriation is a property is unlawful if it is without the owner's effective consent. So if Daniel were to say, hey, you can have my water bottles, it's not unlawful in that situation, right? Because he gave me consent. But if I just take it without asking, that would be appropriation. Does that make sense, to everyone?
Yes.
And consent is not effective if it's induced by force, threat, or fraud. So let's say Daniel says you can have my water bottle, but before he says that, I punch him in the face. Was consent effective in that situation? All right, it was by force. So plain English, juror number 14.
Yes, you mentioned appropriation, definition of, but what about misappropriation, and how do we understand that?
So that is not something that we'll be dealing with in the context of a robbery. Misappropriation is like inappropriately using something, but that has nothing to do with this case, so don't worry about that. Plain English, theft is taking something that doesn't belong to you. So I have a question for y'all. I'm gonna ask you the question, and then there's 4 answers. I'm gonna ask you to raise your card if you fall into each particular category. So the question is, the value of the property taken affects whether I think criminal charges should be brought. Does the question make sense to everyone? Okay. Who strongly disagrees with that statement? So they feel that whether it's a candy bar or a Mercedes-Benz, if someone steals it, criminal charges should be brought. The value does not matter. If it's a theft, it's a theft.
Disagree.
Sorry, I switched my question up and sometimes I confuse myself. The value of the property taken affects whether I think criminal charges should be brought. So if you disagree with that, meaning the value does not matter to you. I'll phrase that better next time. Am I, y'all still confused?
Yeah, I think the way you worded that.
Yeah. Every time I switch it up and then I'll get it one time. So the value, essentially the value doesn't matter. If you agree with that strongly.
I think what it is up there, it says strongly disagree,
Yeah.
but you're asking, do you
Yeah,
agree
So
with that statement?
just after what I'm asking, ignore that. So value doesn't matter to you at all.
Theft is a theft. Is that what you're saying?
Thank you. Theft is a theft.
You're asking if we agree with that.
Yes. Thank you for number. So theft is a theft, value doesn't matter. We have 1, 5, 8, 11.
What do you mean value doesn't matter, like if it's the cost of it?
Yeah, the cost of it. So whether it's a candy bar, if someone steals a candy bar from you, or they steal $1,000.
So you're asking if we disagree or?
No. Let me take this out. So the value of the property does not matter to you. A theft is a theft, no matter if it's a candy bar or $1 million. If you agree with that statement, raise your card. Everyone with me now on the question?
All right, so just 1 second, I'm sorry. Everyone here, everyone, please lower your cards. Here's the question. Does everyone here believe that a theft is a theft and it doesn't matter what the value is? Is there anyone who disagrees with that statement? All right, so lower your cards again. So here's a statement. A theft is a theft. The value doesn't matter. Does everyone have that statement in their mind? Is there anyone here who disagrees with that statement? Yes.
So the people who are raising your cards now, you're saying that the value does matter.
Yes.
Well, let me flipping it. So yes, the value does matter to you. Okay, so let's get, so we're doing value does matter to you. 2, 4, 6, 7, 12, 13, 20.
Did you say value does matter?
Value does matter. 18, 21, 24, 26, 37, 36, 39, 34.
I'm not sure.
Okay, I'll go ahead and touch 34, 40, 41, 42, 40, I got it. 44, 45, 48, 57, 63, 67, 68, 69, 73, and 74. So ignore that slide, y'all. So then, now that we know what a theft is, let's talk about what a robbery is. A person commits an offense if in the course of committing theft, as defined in chapter 31, which is the definition I just gave you, and with intent to obtain or maintain control of the property, he or she intentionally, knowingly, or recklessly causes bodily injury to another. Your number 11. You raise your card.
Oh, I thought you were asking.
Okay. So now we have me taking Daniel's water bottle. Instead of me saying, Daniel, I'm gonna punch you, I actually punch him and I cause some sort of injury. That's what that's saying. Does that make sense to everyone?
Yes.
So in the course of committing theft, that has a legal definition. In the course of committing theft means conduct that occurs in an attempt to commit during the commission or in immediate flight after the attempt or commission of the theft. So this is just covering the entire span of the theft. So whether I threaten to punch him before and then I take it, or if I'm trying to get away with it and I punch him, all of that is in the course of committing the theft. Does that make sense to everyone?
Yes.
Bodily injury has a legal definition. Bodily injury means physical pain, illness, or any impairment of physical condition. It does not require a visible injury. The victim can testify to the pain suffered. So does everyone understand the legal definition of bodily injury?
Yes.
Does anyone have any questions why it does not require a visible injury? Juror number 46. Yes, sir. Nope. I'm sorry.
You guys.
46.
Does that definition include emotional trauma?
No, we're just talking about physical, yeah. And so would everyone agree with me that not all injuries can be seen?
Yes.
Like there can be internal injuries, or sometimes like some people just don't bruise, but that doesn't mean that they didn't feel pain, right? So the next question, hopefully this one's worded right, we'll find out. Even if there is not a visible injury from the robbery, criminal charges should still be brought.
Yes.
Does that make sense? Okay, so let's go. Who here strongly agrees with that statement? Oh, wow. Okay, let's flip this since I got a lot of y'all. Let's go to number 4. Who strongly disagrees? Because if I rephrase it, then it's gonna. I got it. 36.
I'm just confused on this.
Okay, so if there is not a visible injury from the robbery, criminal charges should not be, or should still be brought. So essentially, if you're 4, you require an injury. You require some sort of visible injury. So does anyone say, I need to see an injury from Daniel before I can think that criminal charges should be brought? Okay, so everyone is okay with no visible injury. And then I told y'all that most words have legal definitions. The course has said where there's no legal definition, we just use the ordinary meaning. So I just included that. Earlier, the judge said, state, we have the burden of proving all the elements of the crime. Elements is a word that we use in law school. It's basically, it's just how we break down the law. And so it's like building blocks. And so we break it up into elements so that it's easier for us to make sure that we prove everything that we need to prove. And also it makes it easier for us to explain what we have to prove. So whenever you hear the word elements, there's not some special meaning, it's just how we're breaking down the law. So the elements of theft, and this is what we, Daniel and I have to prove, is on or about a certain date in Bexar County, Texas, the defendant unlawfully appropriated property with intent to deprive the owner of the property. That's a theft. Those are the elements. So for robbery, on or about a certain date in Bexar County, Texas, the defendant, in the course of committing a theft with intent to obtain or maintain control of the property, intentionally, knowingly, or recklessly cause bodily injury to another. Does that make sense, everyone? Does everyone understand what the elements of robbery are? It's broken down what we just discussed. So one thing we haven't discussed, we have to prove intentionally, knowingly, or recklessly. All of those words have legal definitions. Intentionally, it is your objective to engage in the conduct or cause a result. Knowingly, you are aware of your conduct or understand that the consequences of your actions are likely to cause a result. Or recklessly, it's a conscious disregard of harm that may be caused by your actions. I guess to break that down, let's say I said, Daniel, you're taking bad notes. I need you to do better, and I punch him. Was that intentional?
Yes.
Yeah. How do you know it was intentional? I stated it, the action. I look at him when I did it, right? Your number, what's your number? 49. Proximity, yeah. So now let's say instead of me saying all of that, I just look at Daniel, I see that he's within arm's reach, and I do that. Was that intentional?
Yes.
Most likely, right? Was it at least knowingly? Yeah. And so recklessly, let's say instead of picking on Daniel, I was like, and I just threw this clicker out into y'all tightly crammed in. Am I intentionally hitting juror number 42? Thanks for volunteering. If I hit juror number 42, is that intentional? Probably not. It is reckless, right? And so it's sort of like it's a lower burden. So intentionally is the highest burden, knowingly, and then recklessly. Either one is what we have to prove. How do we prove mental state? This is what we just talked about, by someone's statements, either actions or the surrounding circumstances. What we don't have to prove, anything that wasn't one of the listed elements. So if it's not one of those things, not on or about a certain date, Bexar County defendant in course of committing theft, caused bodily injury, etc., we don't have to prove it. For most cases, people want to know why someone did something. That's not something that the state has to prove. It's not the burden, it's not on us, and it's not an element. Does that make sense to everyone? Is anyone going to require us to prove why the defendant did anything, or why the defendant committed the offense? Your numbers 63 and 69. 63. Yes, ma'am.
Answer is yes.
Yes, you would require us to prove why. Okay. And so knowing that that's not what the law requires, you're still saying that you're gonna require the state to prove it.
I'd like to know.
I definitely understand that. We all want to know, but what I have to know and what we all need to know is, are you gonna require us to prove it to you? Okay, so if we prove all of those elements and you never hear why a defendant committed the offense, you would still be able to find someone guilty.
Not sure.
You don't think so? Juror number 69.
Why wouldn't you?
That's a good question. So who knows why anyone does anything? The person who does it, right? And so that would put an impossible burden on the state because we're not in the mind of that person committing the offense. And so the law only requires us to prove what the law requires, and which is what we can prove, that that person committed an offense on that date. We don't always know the backstory behind things. So juror 69, I guess, how do you feel about us not having to prove why? You okay with it? Cool.
Me too. I know I have to prove why. I always ask my kids, why did you do it?
So you want us to have to prove?
Yeah.
We have to prove why to you. Okay, so does anyone agree with juror number 18 and 63 that we need to prove why? 20 also? 4. Okay, so let me start with 4, sort of the same questions that 43, are you planning? Or
My mind.
Okay, let me write you down. So I got 4, 34, 43, 18, 19, 20, 21, 32, 44, 47. And so, what I said to juror number 69, obviously we all want to know why something happens. The judge talked about the Fifth Amendment and the defendant's right to not testify. And so just like you can't hold that against the defense, you can't raise the state's burden. And so the elements are what we have to prove, that on or about a certain day, the defendant committed this offense. And so I could ask a lot of questions, but essentially I'm just gonna ask, if we don't prove why, would you be unable to find the defendant guilty? And I'll go through. So would you be essentially you're raising our burden, you're making us prove something that the law says that we don't have to do. And so I'm gonna go through and say, would you be unable to find the defendant guilty if we prove all the elements to you beyond a reasonable doubt, but we don't prove why? Juror number 4. Yes. So if we prove all the elements to you beyond a reasonable doubt, but we don't prove why, would you be able to find the defendant guilty? No, okay. Thank you. Juror number 18.
I can't hear you very well. What do you think?
So if we prove all the elements to you that were required to by the law, but we don't prove it to you beyond a reasonable doubt, but we don't prove why the defendant committed the offense, would you be able to find the defendant guilty?
Of course.
You would. Okay. Juror number 19.
No.
Juror number 20. No. Juror number 21. Juror number 32. Juror number 34. Yes. Juror number 43.
No.
Juror number 44.
What you said?
Yes. Yes, right now. Juror number 47.
Yes.
Is there anyone that I missed? Juror number 1. Okay, so if we don't prove why, you would not be able to find a defendant.
Right.
Okay. Thank you, everyone. Anyone else I missed? Another part of the law that I want to talk about is the law of parties. Legal definition. This is what the code said. Parties to offenses. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct, or by the conduct of another for which he is criminally responsible for, or both. The question is, when is someone criminally responsible for the conduct of another? Play another guessing game. Who knows what movie that's from? Ocean's 11. They're gonna get a little bit harder. That one. Yeah, Italian Job. That one. Yeah. What about that one? Set It Off. Funny, yeah. Judge knows I didn't know, I don't know that last movie. I looked it up. I was like, I know the name, but I've never seen it. 1967. So, yeah. Would everyone agree that these actors in these movies committed the offenses together as a group?
Yes.
That they were all a party to, in Ocean's 11, robbing the casino, right? They all played a separate part, but it was all to accomplish the same goal, would everyone agree?
Yes.
And so the law says a person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. So knowing the legal definition of when someone is criminally responsible for the conduct of another, does everyone still agree that all those examples fall under law of parties?
Yes.
So let's talk about like classic bank robbery example, getaway driver. Again, hopefully I worded this right. But in the example of a bank robbery, you have a getaway driver and you have the person who actually goes in and holds up the teller. Who here feels that the getaway driver is just as criminally responsible as the person holding up the gun teller? Is there anyone who feels that the getaway driver is not as responsible as? Okay, so we have 3, 19, 20, 21, 40, 59, 62, and 63. And so for all of you in 22, I think I have a question later, but I think I'll go ahead and ask it now. So for those of you who raised your cards just now, is there anyone who would not find the getaway driver not guilty, even knowing the law of party says that they are criminally responsible? So let's say we were going through a trial for robbery and we had the getaway driver on trial. And we proved that he aided, assisted, that he was a party to the robbery. And we proved it beyond a reasonable doubt. For those of you who raised your card that said that he is not as criminally responsible as the gun person, would any of you find that getaway driver not guilty? So you would be unable to follow the law of parties in that example. Juror number 40, 62. Anyone else? So everyone else, even though you maybe think that the getaway driver is not as bad, I guess, you would be able to find the getaway driver guilty. For those of you who raise your cards.
Yes.
That's the definition again. Here's another example. So the guy with the blue jacket, maroon beanie, can y'all tell what he's doing? Yeah, he has a backpack out. It looks like he's about to put it in his backpack. What about the guy with the glasses? Yeah. Oh, yes. Does everyone agree that they're acting as a party to commit a theft in that situation?
Yes.
Juror number 38? Okay.
Oh,
Okay. Does anyone, this was the question I was gonna ask, but does anyone have a problem with the guy with the glasses being held responsible for that, just as the guy with the backpack? Okay, so nope, everyone still feels the same way as you did with the bank robbery getaway driver, right? 40.
I disagree. I think the lookout, you have to be sure that he is a lookout.
Excuse me, what is your number?
40. Oh, I'm 40.
All right.
You have to be sure he is a lookout and that he's not just in the wrong place at the wrong time.
100%. And so my question is assuming that you believe that he was a party to the offense. So not that he was just standing there, that he was aiding, assisting, encouraging by acting as a lookout to help commit the crime.
In other words, he's knowingly aiding and abetting.
Yes, ma'am.
Okay.
So
then
you believe that he was aiding in the theft?
knowingly abetting, then I think this is wrong.
Okay. Judge went over the burden of proof, so I'll just go over it quickly. It's beyond a reasonable doubt. It's not 100%, not removing all doubt, not beyond all possible doubt, not beyond a shadow of a doubt. It's beyond a reasonable doubt. It's the same burden standard that's used in criminal jurisdictions across the US, from traffic tickets to murder cases. It's a high burden, but it's one that we gladly accept and we intend to use. Judge went over one witness rule. Some of you raise your cards. I have 12, 13, 26, and 36. All of you said that you would be unable to follow the one witness rule and find someone guilty based on just one witness. Is that right? Juror number 12.
Yes.
Okay. You would be unable to find someone guilty? Or you can, based on one witness?
I can,
You can.
yes.
Okay. 13.
I'm sorry, yes.
I really didn't hear that, the question.
All right, so if you can repeat the question, if everyone can remember to please speak up so that Brenna can hear and so that I can hear and so that both sides can hear.
So the question, and the judge sort of gave an example of, let's say you're walking in a dark alley, someone commits some sort of offense, they shoot you, they rob you, whatever the case may be. You go to the police station, you say, hey, I know who did it. Let's say it's juror number 4. You're like, juror number 4, I was in court with her all day. I can identify her. And the person at the police station, they're like, was anyone else there? You're like, no. Were there any cameras? No. You have any additional evidence? And you're like, no. Then the officer's like, sorry, I can't do anything. Does anyone think that that's fair, that that's right? Yeah. And so that's why we have the one witness rule, because sometimes there is only one person there, because oftentimes the criminal is the person who chooses where the offense happens, right? And so the question is, if we were to only prove our case through one witness, and we just brought one witness who takes a stand, that they prove all the elements to you beyond a reasonable doubt, and there's no additional evidence. Does anyone have trouble finding someone guilty based solely on that? Juror number 35, do you have a question? Or you?
Yeah, I got a question.
Yes, sir.
You know what? I admire the other people on the jury who are telling people to stand up. I appreciate that.
So my hesitation is, I don't know if I could or if I couldn't. I just, just through research and things I've learned, that you can see something, but what you see or what you thought you saw is not what you actually saw. And I know and understand that. So to have just one person say it, I would think, well, maybe.
And so you're adding something, and this is what the judge cautioned you about.
That's why I didn't want to say anything before, but it's still in my head.
Yeah, don't add any additional factors. In this scenario, you don't have those second thoughts. You're like, I believe that person, they're credible, beyond a reasonable doubt, whatever that is. So you don't have those second thoughts. You're convinced beyond a reasonable doubt that of what that person said proves all the elements to you beyond a reasonable doubt. Is there anyone who's like, even though I'm convinced beyond a reasonable doubt that that one witness proved all the elements to you, or to me, I still need something else? So who here still needs something else, even if they're convinced beyond a reasonable doubt by one witness?
That they're guilty.
Yes, that the person's guilty, that they committed the offense. 4, 15, 18, 20, 21, 40, 43, I see 65 and 66. Okay, juror number 36. Okay, which part?
I'm just confused because we're kind of out to the two scenarios.
Mhm.
So I'm just kind of like, because you're explaining the one,
Mhm.
but then I'm not seeing how like, are you saying if there's one witness,
Mhm.
they're saying this is what happened.
Yes, ma'am.
You're asking if we are going to still prove guilty, only having that witness. It's testimony.
Yes, and so we only have that one witness, but you're convinced that they prove all the elements to you. So that one witness meets all those elements on or about a certain day, he committed a robbery. And so you believe that witness beyond a reasonable doubt. Are you still like, even though I believe that witness, I still need more than that? I need a second person, or I need photos or video, whatever it may be. Or is that one witness going to be enough for you? That one witness won't be enough for you. Okay, 36.
All right, and everyone, here's the one witness rule, because I know sometimes we get caught up in other things. The hypothetical is and I'm going to pause your time save. The hypothetical is the hypothetical. So when you have someone who comes and testify in the one witness rule in the hypothetical, and you're like, well, I wonder if maybe they're confused. Then when you say, I wonder if maybe they're confused, that means you're not finding them credible. So in the one witness rule, when that witness testifies, you don't have any questions about whether or not they're confused. You know they're not confused, and you believe their testimony. And that one witness could be Mother Teresa. It could be the Pope. It could be somebody's mom. It could be the lady down the street who always tells the truth. It could be anybody. So in the hypothetical with one witness, there's no reasonable doubt in your mind. You're not saying, well, maybe she or he, have a vision problem. And the hypothetical, that person doesn't have a vision problem. And the hypothetical, you're not saying, I think they're confused. None of that is in the hypothetical. Person is called as a witness. They raise their hand to tell the truth. They tell the truth. And everything that they're saying proves every single element that the state has to prove. And you're not questioning whether their vision is 20/20. Their vision's 20/20. You're not questioning whether they have any type of bias against someone. That's not in the hypothetical. Does everyone understand? So when the state is talking about one witness rule, that's the hypothetical, because you have to find the person credible. If in your mind, when the one witness and the hypothetical testifies, if you have an issue with their credibility, then it's not that you have a problem with the one witness rule. It's a problem that you have with the witness because you're not finding the witness credible. Does everyone understand the hypothetical now?
Yes.
All right, state.
Your number 68.
Sorry, I just had a quick question. When you say one witness, hypothetically speaking, are we talking about, you're saying the victim is the one witness? No one else seen it, but who it happened to is the one witness? Is that what y'all are saying?
So that's adding something to it. It's just one witness. We can't say whether it's the victim or it's someone who watched, who saw it, whether it's a police officer, it's a witness who takes a stand and swears to tell the truth. So the people who I have who said that they would still need more than one witness, let me know if you still feel the same way. 4. Okay.
Because in my head, like I'm thinking hypothetically, like if something, like if someone was confused, but like that question is
Okay. And so even, I don't know which example, I guess, description sort of helped you more, whether it's the judges or mine, but imagine you don't have any doubts about that person. And so you believe that person.
Yeah, okay, say the question.
Yes, so if one witness were to take the stand, you believe that witness beyond a reasonable doubt, so you have no questions about what that witness is testifying to as far as the elements go. You believe that they prove all the elements to you beyond a reasonable doubt. Would you be able to find someone guilty based on just that one witness proving all of those elements to you? Or would you need more still? Okay. And I have to lock you in. Either say, yes, I can find the person guilty, or I can't. And there's no wrong answer. Just need to know how you feel. You can't. You,
Yeah, I'm confused.
okay. We'll come back. Yeah, there's no wrong answers.
So I can't find the person guilty based on
Okay, thank you. 15. What? Can you speak up?
So the witness can be clear-headed,
believable, but humanity.
Okay, everyone who's speaking, you're starting here and then your voice is going down. And so Brenda's having problems hearing, and I know I'm having a problem hearing the answer. So if everybody could keep their voice up so we could hear, that would be great.
So the witness to be clear-headed, there's no deviation from that. I still believe humanity to be unpredictable. So even if we prove all of the elements of the law, I cannot say that beyond a reasonable doubt.
Okay, thank you. Juror number 18.
What you think?
Okay. Juror number 20. 21. Sorry.
Quick question, so my decision would have to be based solely on the one witness, no other evidence?
Yes, ma'am. One, because that one witness, what they testified to is evidence. And so yes, that one. Okay, okay. 40. You said can't or can't?
I cannot.
Cannot.
You want 40 now?
40, yes, ma'am.
I agree with her.
Okay.
I have difficulty relying on what one witness says.
Okay. Thank you. 43.
Yeah, based on Bible principle, we're three witnesses, I wouldn't be able, based on just one.
Okay, thank you. 65.
I don't think that there's such a 100% absent, like, or Mother Teresa, who I don't think. Start over.
Did you say that again, ma'am?
I said, I find the concept hard to imagine that there's a witness that's 100% credible. Because I just have a hard time.
66.
I cannot find guilty with one credible.
63.
The same, I would need more than just one witness.
Okay. And juror number 1, you raised your card earlier. Need a break? Okay.
All right, are you able to hold on for just 5 minutes or no? All right, so what we're gonna do, then we're gonna take a short recess. And so what that means is that when one juror leaves, everyone needs to leave. So like in paper chase, look to your left. Look to your right. All right, so the reason why I have you do that is because we can't start unless all of you all are here. So I'm gonna have all of you step outside and we'll come back at 11:25. The restrooms are located near the stairwells, so you can go on any floor. All right, everyone, please rise.
rise for the jury.
Noise.
I know they are hard. It's hard.
All right, so before I turn it back over to the state, I just want to let you all know, if you see attorneys for the state or the defense or me in the hallway and nobody's speaking to you, it's because they're really not allowed to. And this is the only time they're allowed to speak to you in the courtroom. And of course, that used to always be hard for me because my mom and my grandmother always said, doesn't hurt to smile and say hello to people. So just know that if they're not, you can come in. Is she coming in?
Yeah.
All right.
May I get it?
Yes. All right. So just so you know, when they don't speak to you, no one's trying to be disrespectful. And I'm not trying to be disrespectful because Brenda will tell you I speak to everybody. So just realize that's the reason why. Okay. Okay. All right. Then with that being said, we're going to resume with the state. States, you have 6 minutes.
Thanks, Greg. Just a few more minutes. Want to talk about the types of evidence. Witnesses, anyone who takes a stand, they swear to tell the truth, that's evidence. This is an example of like a robbery. There are videos, if it's offered and admitted into evidence, that would be evidence. And then the physical evidence, whether it's photos, whether there's like an actual gun, sometimes with fingerprints, things like that. All of that is evidence. And if it's admitted, we take it back to you and can use when you're deliberating. One thing that I want to mention that's not evidence that won't go back is police reports. We always get questions about that later on, but there's rules that say police reports can't go back. So if you're chosen on the jury, just give you a heads up, you won't see any police reports taken back with you. This is a question for everyone. Have you, a close friend or family member, ever been arrested, charged, or convicted of a theft, a robbery, or a similar offense? And ultimately, the question is it to the point to where it would affect your ability to be fair and impartial in this case? Like my example with the burglary. Juror number 11, 12, 4, 38, 1, and 51. So all of you that's raising your cards, it would have, I guess the question is, like I said, would it affect your ability to serve on a jury in this case? Like you would be able to be fair and impartial to either side. 1. Did you answer verbally now?
Yes.
ability to be fair and impartial? Okay, juror number 4.
I will kind of family. I think I've been on those nights, so I feel like
Okay, so would you be unable to be fair and impartial for this known as a robbery?
I was-
Okay, juror number 12,
Question, arrested, indicted, is that the same?
doesn't matter if they've ever been anything.
Yes.
Okay, you would be unable to.
Yeah.
Okay, who else raised their card?
Pretty
Any-
unable to.
Unable to? 11? Okay. Everyone's probably me too, Brenda, so I'm sorry. Everyone's getting lower. I guess as the day goes on. So if y'all can speak up, 44?
Well, I didn't, but I
Look about it.
so, find out if you not, telling the truth or nothing. My son was convicted, but he's the one that asked the judge to give him the punishment that he needs. If you choose, you choose. I raised him to tell the truth. If you did it, you did it. Just go with the punishment and that's it.
So would you be able to serve on a jury knowing that this is a robbery case?
Yes.
Skip that one. Does anyone here, has anyone had any sort of negative experience with law enforcement that they think would affect their ability to be fair and impartial in this case? I know most of us have had negative experience with law enforcement, but the question is, knowing that law enforcement may be called as a witness, even if it's not the law enforcement that you dealt with, just because of that experience that you had, you would be unable to be fair and impartial. You would hold it against the state or hold it against most likely the state because of your past experiences with law enforcement. And you would use that in making your decision in a case today, or in this case. 1, 8, 11, 12, 18, 19, 20, 29, 37, 40, 43, 56, and 62. Is anyone uncomfortable sitting in judgment of another person because of religious, moral, or philosophical beliefs? So if you're chosen on the jury, you would be unable to reach a verdict because you would feel that you're sitting in judgment of another. Number 1 and 43. And then lastly, is there anything that I didn't ask that you think that we should know that's important that I didn't discuss, but you think that we should know in order to make a decision about whether this case is right for you? 21?
May I speak to you privately?
Yes, yes, ma'am. 18.
I had 2 daughters and they got robbed, and so it's really touching to my heart.
Okay, thank you. 47?
I had a family member who was injured due to a robbery that caused time changes time, so I feel real strongly about regardless of what they steal or how much it is, that I just feel that it can destroy someone's life regardless of the value of an item.
Thank you. 46?
I've been the victim of robbery twice, so I'm very strong.
Okay. 38?
You know, when I was 12 years old, I had a guy pull an outside in. Didn't really have anything. I don't know, it's just my grandfather's car, but I still remember his name, so.
And I'm running out of time, so I'll just get numbers and we may come back to it. 11, 15, 26, 27, 37, got you, 20, 55, 60, and 21. I got you. Thank you, Judge.
All right, thank you. Defense?
Thank you, Your Honor. May it please the court. Say, the hardest part about being defense is we go last. When everybody's already tired and going, folding their arms and saying, oh my God, now we got to listen to the old guy. But I'm going to ask you all that, so let me say this first. The jury card that you all filled out you all as a panel are probably the most highly educated panel that I have seen in my 25+ years. Very highly educated, very smart, listening to your responses and answers, you're thinking things through. I know these hypotheticals are tough because everybody wants to know what's going on. The law is not like TV. And everything you've heard and learned about the law, I'm going to ask you to think about it a little bit different about the law. It really is. And some of our beliefs, it's going to be hard to flip that and understand that. Why? Because we all come in here with our own biases, our own life experiences, and what is going on. And I'd like to start off with this question. Who here believes, and I feel that as each day passes, we as citizens of Texas and the United States are losing more and more of our constitutional rights? I'm a lawyer and I see it. I'm not sitting there saying just playing politics. I'm not saying the Republicans are taking things away, the Democrats things taken away. We just seeing things being watered down. And we sit there and say, well, it's not really affecting me, so I really don't care. Until it does start affecting me, and then I care, but that camel's already kicked in the door. As the judge said, we ask very little of our fellow citizens, and that is to serve on jury duty. The beautiful thing about jury duty is this. You, the 12 that are picked, you get to decide if I'm going to water down what our law says, or I'm going to keep that bar where I believe it is. The judge can't tell you to do it, the state can't tell you to do it, I can't tell you to do it. You all will get to decide what beyond a reasonable doubt really means to you, what presumption of innocence really means to you. And do I, as a citizen, sit there and say, you know what? I'm not the one sitting there, but it could be a loved one. It could be my father, my mother, my brother, my sister, cousin, sitting there at the defense table. And I want those 12 people to hold the government to their burden. And that's what that burden means to me. One of the first things I want to ask you is simply this. It's a silly thing, but we're all trained this. We all stand to watch y'all walk in. And everybody walked in and he started looking around the courtroom. Clearly that's the judge. She has the black robe on. All right. That's probably the prosecution table. They're the younger, better looking guys. Over here, we got the older guys. And then you all looked at Mr. Curry. And just be honest with yourselves. How many sat there and said, I wonder what he did? All right. Or let me ask you this. How many sat there and said, there sits another innocent person? Really? Number 63, you thought that? Good for you. Good for you. And the reason I ask it that way is this. It's our natural tendency to walk into a courtroom. We're here for jury duty. We know it's a criminal case. One, what it's about and what they did. Right? And that's a natural tendency. But the judge mentioned something a little bit earlier, and that's called the presumption of innocence. We'll talk about that just for a minute. Okay. And again, that's one of those pillars that you all decide what that means. The presumption of innocence is actually like a cloak that sits around every one of us that are accused of a crime. It's upon our shoulders. So when you're looking at Mr. Curry, yes, he is presumed innocent. And that cloak remains on each and every one of us until and if the state can prove beyond a reasonable doubt each and one of those elements of the crime. And we have to prove, we have to prove, we have to prove. What presumption of innocence really means is this. As a juror, we're not looking at ways to convict. We're looking at ways to acquit, because that's what the presumption of innocence means. And acquit may be a fancy word by sitting there saying you didn't do it. So when I'm looking at evidence, am I looking at it in the light of guilty or a light of not guilty? And that's tough to do, but that's what the presumption of innocence means. Okay. And again, I can't change anybody's biases in my quick speech here or my questions. But these are things that I really would want everybody to think about as if you were sitting at the defense table next to you. My wife is the kind of person, you can hear a lot about my wife. I don't wear a ring, but me and my wife have been married 32 years now. She's one of those people, she's a school teacher. And so when all of you were raising your hands about, hey, I'm going here, I'm going there, I've got this travel plans, I was envious of y'all simply because I haven't had a vacation in, I think, 8 years now. But my wife, she goes on vacation all the time. She's a school teacher. And somebody's got to pay for those vacations. In fact, my wife just went to Puerto Rico. And that's a good thing. But she's also one of those people that says, close enough is good enough. Heard enough, that sounds good to me. Who here is one of those close enough, good enough mentality? I'm pointing. The reason I say that is this. So I want to talk about beyond a reasonable doubt a little bit. The court has already talked about it. The state talked about it. The state talked about it pretty quick. And that bothers me a lot.
All right, ladies and gentlemen of the jury, this is jury selection. So both the state and the defense are given time to speak to you about whatever issues they want to speak to you about. Does everyone understand?
I can barely hear you though.
All right, who can barely hear me? All right, let me talk louder. I like that. Thank you for letting me know. Can everyone hear me now?
Yeah.
All right, this is jury selection. So what that means is the state and the defense are given a specific amount of time by the court that both sides have agreed upon that time. And they're allowed to talk about whatever they wish to talk about for whatever length of time they wish to talk about it. You understand?
Yes.
All right, defense.
Thank you. So beyond a reasonable doubt. Okay. That is the highest burden that we have. As the court said, we don't have a definition of beyond a reasonable doubt anymore. But let me give you a quick story of what it means to me. And then you all, the beautiful thing about beyond a reasonable doubt is the 12 of you that are selected or in life, this is what it means to me. My wife, about 7 years ago, went in for her normal annual checkup, and they found some, I guess, lumps on her breast. And we went to the doctor, obviously. They checked it out and they said, don't worry about that. Those are just calcium deposits. I'm aware. And I know we have a lot of doctors here, but it's like, that's my wife. Okay. So I made her get another appointment with another doctor. They did the same test, the scans, saw the masses. Don't worry about it. Calcium deposits. She was fine with that. That's not the other. So we went to a third doctor. That third doctor came back and said, there are calcium deposits. There's also cancer. But for me, what beyond a reasonable doubt is, my wife now is 5 years cancer-free. So when you're thinking about it, just because somebody says something, is it enough? Did we get there? Are there other things? Number 40 mentioned something too, which when we were talking about law parties, which I want to talk about a little bit also. The state showed a picture of the kid putting meat into the backpack, right? And the other guy was standing there looking away. And he asked about the law parties, is he part of that party? And almost everybody said, yes. Well, it just followed on the heels of, are you all these other We gotta do critical thinking. That goes to what beyond presumption of innocence is, and what beyond a reasonable doubt is. You hit the nail on the head. How do we know? This part. How do we know? His friend says, I'm gonna go steal some meat, and he says, I don't want anything to do with it. Turns around. We don't know. We can't assume things, right? Assumptions are deadly. Not just in a court of law, but everywhere. Okay, so just because somebody says something, what we're asking you to do is, did they prove that to me beyond a reasonable doubt? Or did they sit there and just because they said it, now I'm going to assume different things away? So let me ask you. Number 3, right? Okay. How do we know? This is your personal experience. There's no right or wrong answer, by the way. If somebody if they're acting together, give me some, what you would be looking for. Proximity over time, repeated engagements. Okay. What about you?
The relationship.
The relationship. So we're looking for actions before.
Friendship, how long we've been friends, what they've done together.
Okay. So one thing I want to clarify about the law of parties is this. To be a law party, you have to engage in that criminal activity either before, during, or after the event. So let me give you a hypothetical. It wasn't me. But suppose you're out on a camping trip, you're sitting around the fireplace or fire pit, and one of your friends says, I want to get high. And he pulls out a joint and he starts to smoke it. And he starts passing it around, gets to you and you say, no, don't want any of that. And you just smoke it. Then the police come up and they arrest us all for possession of marijuana, right? In that hypothetical, I am not a party to the crime. Proximity doesn't get me there. I can be around a crime and not be a party to a crime with certain exceptions. I may have a moral obligation to stop a crime, but I do not have a legal responsibility. Now, if I was to sit there and say, let me roll that joint for you and hand it to him, and it goes around and it comes law parties, right? Yeah. Or after, here comes the cop out behind it, right? That's after the fact, that becomes a law party. So the main thing about law parties is this. Unless you're aiding either verbally or in the act itself, before, during, or after the crime, being present at a crime scene or in the crime or seeing the crime is not against the law. Does everybody understand that? Yes. Does anybody have an issue with that? Number 43.
Yeah, in the case of, I'm sorry, in the case of the person that was stealing the meat and his, you know, the supposed friend said, well, I don't want to be part of this and turned around. He could have just walked out the store and not stayed there with him. So to me, he seems guilty because of the fact, guilty by association, he stayed there. In the case of the one that was smoking the marijuana at a camping trip, instead of sticking around with the group, he could have left. He had that option. So that's my opinion.
Okay, and I get what you say. Does anybody else agree with number 43 for analysis? So number 11, 12, 13, 9, 15, 16, 18, 19, 20. 14.
I have a comment to make with regards to that hypothetical.
Comment away.
This is, doesn't have anything to do with case law, but it has to do with conscience. And you see a crime being committed and rather than participate in terms of thwarting that crime, you do nothing when you can do something that makes you guilty by omission. But that's not case law. So
Okay, I understand what you're saying. Now, that takes us in a different realm. So you could have crimes for commission or omission. You're only guilty of omission if you had a legal duty with that person, such as your parent, right, or a teacher, somebody's under your control at that point in time. By law, then you would have that duty to do it. What your number 43 added was the individual, I know the law says you don't have to walk away. You don't have to do that. But since you didn't, I know what the law means. I don't care. I'm still going to find you because morally you should have, right? So those who agreed with number 43, do you understand that is not the law? Okay. Knowing that's not the law, just by your mere presence and not trying to stop it or not walking away, you would say, I don't care what the law says. You're guilty by association because you didn't stop it or you didn't walk away. Who believes that one? Change your mind. That's number 6, 13, 15, 18, 23, 28. All right, Mr. Pittle's gonna get up and talk to you a little bit, so I'm gonna steal his line right now. I wish the state would have used this, but here's the line. When we're asking a question, because in jury selection, we have to have an affirmative answer, yes, no. So it's kind of like being pregnant. You either are or you're not. And that's Mr. Pittle's line. Okay. You either are or you aren't. We can't be on the fence. I'm gonna come back to you and let you think about it. Looks like you want to jump on. Number 60. 75. 65. What's this?
No, I was just saying, there was another. I lived at a store and I saw a robbery take place. The guy was stuffing t-shirts down his pants. He had really baggy pants. So I felt the moral obligation. He saw me. I know he saw me that I saw him. So my first was like, I'm praying. I'm like, I'm gonna have that. So I went to the cashier and I whispered, I said, check me out real quick. I want to leave. Well, she jumps over and she's like, hey, take all this stuff. So because I've had those experiences before where I felt the moral obligation to let them know, that there was stealing. That's why I feel strongly about that. You have that option to have to report it, etc.
So let me flip it on you. Had you not done that, should you have been charged with aiding and abetting?
No, because I wasn't with, but earlier you were talking about hypotheticals where you're with friends. I didn't know him. He was a stranger. Yeah, but that's why I'm saying I went to go report it because of the fact that I wasn't.
I didn't get to the rest of the numbers back out.
I was agreeing with her. I'm sorry. I was agreeing with her.
Okay. Number 37, number 44. 47. I did. I want to talk about evidence a little bit and just get your impressions on evidence. It is the duty of the government to prove each and every element beyond a reasonable doubt. And usually what ends up happening is they'll show a picture of a puzzle with some pieces missing. So use your common sense, you could fill in the rest. When we're looking at evidence in a criminal case, you can, as a juror, use your common sense, and nobody's asking you to leave that outside. Point is this: you cannot fill in the gaps for the government. You understand what I'm saying? If in the prosecution, they're saying this, they haven't proved up an element beyond a reasonable doubt to you, but they sit there and say, just look at the evidence, you know that's what happened. Okay? That's not your job. Your job as a juror to sit there and say is, you didn't prove it. Which leads me to one more point that was extremely important, and it kind of went over quick. As a jury, and this is probably the hardest thing to understand, we're not here to decide guilt or innocence. We're here to decide guilty or not. Do you understand the difference? What's the difference between innocence and not guilty?
Honestly, I couldn't speak to it. Guilty, obviously meaning that someone they were the ones that committed a crime or were found to be at fault for a crime. Innocence, in my mind, based off of just what I understand innocence to be, would be being completely absolved from the crime. To be not guilty, that's a line that I couldn't draw at this time.
And for the record, that was number 7. Right? Anybody else have any thoughts on that? What about you, sir?
Well, I would say not guilty is just based on the law. It hasn't been proven. There could be strong evidence that it possibly happened, but there's not.
Did everybody hear him?
Yes.
And that's perfect. That's exactly what it's about. That's what our court system's about. That's what trials are about. If we had a system where we had to prove innocence, we'd be a third world country. Not guilty simply says this: I may clearly think you did the crime. Remember, the judge talked about the burdens of proof, clear and convincing. They get to clearly, that's the burden that they could take your children away from you. Clearly did it. But you know what? They didn't prove that one element beyond a reasonable doubt. Therefore, under the law, I cannot find him guilty. Right? Innocence is somebody who, through the Innocence Project or something else, has been exonerated, or whatever that shows that you had nothing to do with the crime or be around the crime, or you shouldn't have been around the crime. So we're not here to play teams. Okay, all we're here for is to say, did the government prove to me beyond a reasonable doubt? The question that I'm going to ask is a very hard one, simply because of what you had answered earlier about people wanting to know motives and stuff like that. It's simply this: who here morally would rely more on their morals than on the law in coming to a verdict in a case? Did that question make sense? Let me just put in what she had said earlier, and it may make a little bit more sense, right? The law on the law of parties was simply this, okay? I don't have an obligation to stop a crime. I don't, with certain exceptions, okay? I don't have that obligation. And I could be committing a crime right in front of me. I could just watch it. Okay. Number 43's version is, yeah, but you should have walked away or reported him, but the law says I don't have to. So morally, she's saying you're just as culpable because you didn't walk away or do something about it. But the law says you don't have to. So to make it easier, who feels just like number 43 about that? They would look more toward their moral values than, you know what, I understand my moral values, but I'm in a jury trial. This is what the law says. I got to put those aside and follow the law. And that's a hard question because it's biases, right? And I'm not, there's no wrong answer. But that's the question. Can you put those moral values aside and just follow the law? Who can't do that? 15, 18, 20, 60, 43, 47. Did I get 63? 62, 73, and 75. Oh, number 1, number 13.
I honestly couldn't say yes or no. Right now, I'd have to, I guess, experience it here. What? It's a different thing when it's, okay, so, you know, someone's getting beat up.
You need me to drop the Mr. Piddle rule on you?
I just don't, I mean,
You need to know more. You'd like to know more facts about what's going on. Okay. Kind of like the one witness rule. I'm not asking you. Who here would believe a police officer is telling the truth solely because they are a police officer? I hear a lot of giggles, but you know, some people. Number 6, number 18.
Just a comment.
Comment away.
Just a comment. All the officers here, well, are good, sound moral character. And to doubt otherwise would be prejudicial. Same thing goes with all the other employees of the state. And this is based on our constitution, on our laws, federal, state, county, etc. We deposit our trust on the state that they are adhering to the law, and the law based on the what our country believes on justice. Therefore, we should provide law enforcement based on their behavior. Every the benefit of the doubt.
Okay.
In terms of trustworthiness.
Understand this. I'm a defense attorney. And I love the police. Okay. So my best friends are officers. What you're saying is based on your general knowledge, feeling, assumptions. My question remains the same though. Not our personal feelings about officers. It's just because you see a badge or that officer take the stand, your first reaction is they're going to tell the truth because he's a police officer. Or to make it a little easier, or I'm going to sit back and listen to what they have to say and then go after credibility based on what they say. That's how I will judge whether they're telling me the truth or not. My question is simply this. I already believe that they're going to tell the truth because they're a police officer. Okay. So does anybody believe that? Number 49, number 75, number 28. That's where I'm gonna start. I'm sorry? That's where I'm gonna start. That begs the question then, are you gonna listen to him fully and say, you know what, maybe not?
Well, your question was, when they get up there and you see them in their badge and their uniform, are you gonna believe them because they're gonna police officer and then go from there? Yeah, I'm gonna start with, yes, I'm gonna believe them. If I listen to them and I hear something that, that doesn't sound right, well, of course, at that point, I'm gonna make another determination.
Okay.
But I'm gonna start with yes.
Yes, so, and that begs the next question then, here. A lay witness takes the stand and says, something. Would you give them that same benefit?
I would give the police a higher benefit.
Does everybody agree with him or disagree with him, or would they hold any witness the same?
I didn't hear what was the other option.
The other option is a lay witness.
Lay.
Anybody else that's not an officer or official, government official, that takes a stand, right? Somebody off the street takes a stand, and they say something. His position is that I would start the police officer at more trustworthy than this other person simply because he is an officer. Well, I'm getting. That's
Well, I don't know. Their testimonies add up.
I was doing
Their
good.
testimonies add up, then you can make a moral decision based on the testimony.
So make it easy for me. After you were saying yes, after you were saying no, what I would like to do is just simply this. Here's one. With number 6. Did everybody hear what number 6 had to say? Who agrees with number 6?
Can she repeat number 40? Can she repeat, please? I have hearing aids and I'm having trouble hearing certain things.
I'm gonna let you answer the question because I don't want to put words in your mouth.
Okay, question was about the trust of a police officer's testimony. When he gets there and begins his testimony, do you give him any extra credibility just because he's a police officer? Do you give him a little bit of trust? Understanding that he may say something a little further down the line that, you know what, you're kind of blowing it and I don't believe you no more. But because he is a sworn police officer, do you give him a little bit extra credibility at the beginning than just anybody else that either side may bring?
For that. Reason for me growing up, we were taught, or like, you respect the law, you respect the officer, and you don't answer bad, you don't talk back, period. So I was thinking.
Listen, I know I'm older than you. This is why my wife wants to retire from teaching. Same thing. I would get beat at school, get home, get beat, and then they'd ask me what happened. Okay, the teacher was always right, and that's the way it was. That's where we grew up. I don't. Things are changing now, but everybody heard what he said. Who agrees with that assessment? 3, 14, 18, 24, 26, 27, 28, 29, 58, 57, 64, 67, 65, 48, 49, and 53. Your dad being an ex-judge, would that affect you in any way? You ever talk about all these cases with your dad?
No.
Never? Have you ever sat on a jury before?
I can't hear you, ma'am.
Sorry, I got caught off guard. No, it wouldn't affect me in any way like that. And we don't talk about cases. He's since retired. Well, not a judge. Been a long time, so if I have a question about it, maybe now, but nothing.
Yes, sir.
This is court. From a jurist perspective, or from the citizen perspective, it shouldn't be prejudicial to anyone part, truly. And that's the main point.
And that's exactly what he hit the nail on the head. That's exactly what the state is looking for, what we're looking for. It's just, we're coming in here with open eyes. Here's the law. Because the court's gonna make the 12 of you swear, I'm going to follow the law. And that's all we're asking. I'm gonna sit down and let Mr. Piddle ask some personal questions of you all. But I need to ask this. I noticed some of you have law enforcement family members. Would that affect, for those of you who do, would that affect the way you would weigh either for the state or the defense? No?
Yes, I have law enforcement within the family. No, that would not sway me one in.
One way or the other?
Yeah.
Number 11.
Assaulted by cops and they dismissed it. And I just really the biggest gang in the United States. They just cover up for each other. They got dismissed. It was crazy. It was off the officer. And I got thrown in the ground. And yeah, be able to do this.
For sure. You know what?
My family member said stuff.
When you say affected, would you be more leaning toward the government before you heard any kind of evidence? Perhaps, or yes? Get closer. Would it or would it not? Yes or no? Does anybody have any? Oh, yes, ma'am.
I do want to add something. If you remember the Farrell Tucker Stephen Smith case, my dad was the lead attorney on that one, but I could still be higher.
Okay. Does anybody have any questions of me? No, because y'all want to go to lunch. Okay, so I'm gonna let Mr. Piddle speak for a little bit and he's gonna ask some follow-up questions. I really do want to thank you for your time.
It's afternoon now. Good afternoon. I'm just going to ask some follow-up questions regarding your questionnaire that you guys answered. You're number 2. You served on a criminal jury before. What type of case was that?
It was
Murder. Okay. How long ago was that? About 3 years ago. Okay. And did the judge or the jury assess punishment? Number 3, you served on criminal jury as well? Yeah. Okay, what type of case was that? Capital murder, okay. How long ago?
That was 95, 96, 97, thereabouts.
Okay, so you were 28?
It's roughly.
Okay. Well, it's a capital murder, so was it a death penalty?
Yes, yes.
Okay. And so what happened?
I was an alternate and I left before judgment was rendered.
How'd you feel about that?
Let the law play out and the jurors would assess the evidence and I was not asked to assess it.
Okay. Is there anything about this case that would affect your ability to be fair and impartial? Okay. You talked about giving a higher benefit to a police officer who would have testified as opposed to a lay witness.
Yes.
Can you elaborate on that a little bit?
Yeah, so I think there's a certain standard there, like police have chain of custody, and there's a certain rigor behind their evidence, and therefore by default, I would assume until I had reason to doubt otherwise.
Okay, so I just want to make sure that, so the law says that you are the judge, every witness who takes the stand is by the same credibility. Can you judge a lay witness on the same level of credibility that you do a law enforcement officer? So you're not gonna give him a higher benefit, he's not gonna start up here and a lay witness down.
No, I would give the same by default to listen to the evidence if I heard other, something to make me question their credibility.
Who can't do that? Let me show cards. Who can't give the same credibility to a lay witness that they do to a law enforcement officer? Who's gonna start a law enforcement officer up here as soon as they take the stand and before a word is out of their mouth, as opposed to a lay witness that's down here? Number 6, number 18, number 24, number 49, number 57, number 58, number 65. Thank you. Thank you, sir. Juror number 5. Do you have any questions for us? Okay, is there anything that affects your ability to be fair and impartial?
No.
Okay, thank you, ma'am. Juror number 7, same question. Anything that would affect your ability to be fair and impartial?
No.
Okay. You were a case manager for a law firm,
Yeah, pre-litigation.
pre-litigation, okay. The fact that you're involved in the legal fields, anything that would affect your ability to be fair on a criminal jury?
No.
Okay, thank you. Juror number 8. You had I think you raised your card in regards to a previous experience with law enforcement. Okay, assuming that whoever that officer was doesn't take the stand in this case, would that affect your ability to be fair and impartial in this case for Mr. Curry? Or can you set aside what happened to you and judge the facts and the evidence that come about in this case? No, you cannot. Okay, thank you, sir. You're number 9, you're retired from what? Finance and accounting, okay. Anything that would affect your ability to be fair and impartial in a case like this? Thank you, sir. Do you remember? Number 12, your spouse is retired from what? Accounting, okay. You had a previous bad experience with law enforcement or know someone who did? Would that affect your ability to be fair and impartial in this case? Thank you. You're number 13. You raised your card regarding the guilty by association question and issue that your number, I think it was 40 or 43 had raised. Can you elaborate a little bit on that? What your feelings are on that?
I just think that if you see something happening that's illegal, that if you continue to stay there while you're, if you can leave without being hurt in any way, that you should, and you should report it, or if not, if anything, leave, because then you know something illegal is happening and you're just staying there and allowing, and not actively being a part of it, but you're still there, and that means, you should have known better, you should have known.
Okay, are you talking about in regards to what juror number 40, like she saw a theft or a robbery and she had a duty to do something? Or you were a party with another person and you had,
Yes, I think that's when that question was asked of me. I didn't, I knew I answered the question, but then I think. So explain more in detail, and that's what it was, like with the camping trip. You stay there, yeah, you have the right to leave, you can leave by staying there and allowing it to happen. And
2 minutes.
you didn't participate, so, I think you should still, you could still be, have this practice.
all right, thank you, ma'am. Number 16, you served on a criminal jury?
Yeah.
What type of case was that?
Possession of a handgun.
Did the judge or the jury assess punishment?
No, gosh, it's a long time ago. I want to say the judge.
Okay, thank you. You're number 22. Would you stand up, man? Anything that would affect your ability to be fair and impartial? Okay, thank you, man. You're number 26. think you had raised your card regarding knowing someone or actually being a victim of a robbery case. Is that correct?
Me.
Would that affect your ability to be fair and impartial in this case?
No,
No, it shouldn't.
it shouldn't.
Okay, so. You're pregnant or not?
No, no.
No? Okay, I'm not saying you're pregnant, I'm saying the hypothetical. Good thing I only have a minute left. I apologize. Okay, so not affect your ability to be fair and impartial. Okay, thank you. Number 27, can you sit up? Were you a victim of a robbery, man? Okay, would that affect your ability to be fair and impartial? Okay. I don't think so. Yes or no? You think maybe this isn't the right type of case for you, since you've been a victim of a robbery before? Okay, so you think it would, you agree with me, it would affect your ability to be fair and impartial? Okay. Anyone who raised their card to actually being a victim of a robbery, could you raise your cards again, please?
Time,
That's one question.
time.
Thank you.
All right, ladies and gentlemen, what I'm going to do is I'm going to send you on your lunch break. And then we'll come back and make a decision. A decision will be made on who's going to be sitting on the jury. The reason why I'm giving you your lunch break now is for two reasons. One, because sometimes people want to have their lunch break. And all right, I'm going to shout. Here we go. So I'm going to send you all on a lunch break. When we come back, you will know who's going to be on the jury or not. There are two reasons I'm giving you your lunch break now. And that one is because everybody needs a lunch break. Sometimes people say people get hangry when they don't have their lunch. So I don't want that to happen. And number two, Brenda has been taking down everything that everyone is saying. Some people whisper, some people shout, some people talk fast, some people talk slow. And I want to make sure that she has a break so her job can be easy for her. All right. So remember what I said. Nobody from the state or the defense will be speaking to you in the hallway because they're only allowed to speak to you when you're in the courtroom. So if they don't smile at you and they don't say good morning or hi, they're probably thinking good morning in their mind. So don't hold that against them. All right. So this is what's going to happen. We are going to come back at, let me see, what time is that? Almost 12:30.
Yes.
We're going to come back at 1. I'm going to say we're going to come back at 2. Everybody's like, oh. Well, here's the thing. So the reason why we're coming back at 2 is because even though this is jury selection, I also have a docket and I have other people who are waiting on different cases. So when you see people coming through the doors to speak with me, they're speaking to me about other cases, not about this cases. And sometimes I'll have officers who want to speak to me about something else, maybe search warrants or something of that nature. And I have to take that up because that's a part of my duties. So that's why I say 2 o'clock, because the last thing I would want is for me to say 1:45 and then everybody's hanging outside at 1:45 and you're wondering, why isn't the judge starting at 1:45? And I'm not allowed to go out in the hallway and say, I'm starting at 1:45 because I have 4 of the cases that are going right now. So everyone, as my mom and my grandmother always tell me, put some patience in your pocket, take it out as needed, share with other people who need it. And remember, today is Wednesday. So guess what? We're closer to Friday than we were yesterday. So everyone, please rise for the jurors. Oh, please read the numbers. And there's a cafeteria downstairs and also places along the river wall. And sometimes we don't take advantage of seeing the beauty that's in the wall. So enjoy your day. It's not too much there. You're welcome.